SJC-12369, Michael Carey and others, v. Commissioner of Corrections.
Mr. Singer, good morning.
Good morning, Your Honors. May it please the Court, I'm Leonard Singer, and along with James Panjon, Bonita Tenerello, and Sarah Wunsch, I represent the plaintiff appellants in this matter. In this case, Your Honors, the plaintiffs claim that the Department of Corrections must go through the Administrative Procedure Act procedures prior to implementing dog searches of visitors at DOC facilities. What I'd like to start with this morning is DOC's assertion that the public has no right to enter its facility. And for that proposition, it relies on Chapter 127, Sections 36 and 37. And in particular, Section 36 says that with some exceptions, like the governor, judges like Your Honors, have no right to enter a DOC facility without the permission of either the commissioner or the superintendent. And DOC says on page 38 of its brief, indeed, Section 36 alone would permit the use of dogs. The problem here is that Section 36 is not alone. There are at least two other significant other things that limit DOC's discretion with respect to search procedures. The first of those is the regulation that DOC itself promulgated. A regulation, once promulgated, is binding. It has the force and effect of law, and it's binding on DOC. So looking at that regulation, Your Honors, we submit, and as I've argued in our brief, that it limits DOC's search procedures to those that are similar to the specific enumerated procedures. And I'm not going to, unless Your Honors have some questions about the statutory construction arguments that are made in our briefs.
Can you focus on the language itself? So there are two, I was going to focus on the first two sentences. Each superintendent shall establish a search procedure that is effective in preventing the smuggling of articles into the visiting area of the institution. That's pretty broad, right?
That's correct. That is very broad, Your Honor.
So if that were, they stopped there, you'd be in trouble, right?
I think that's fair to say, Your Honor.
So then the next sentence, the search procedure may include as a prerequisite to admission that visitors successfully pass through a metal detector and or a scanner, and then this part, and or a personal search, and that articles they are carrying be thoroughly searched. Why isn't that and or a personal search? Why wouldn't that cover more than just, metal detectors? Why wouldn't that cover a dog search?
Because, Your Honor, personal search is a defined term in the regulation itself. There's a language in the regulation which talks about.
And what is that? What is the definition of the personal search in the regulation? If you don't know right off the top.
I don't know right off the top of my head, but it's there. They talk about it and things like removing jackets and things of that nature. And I think what personal search contemplates is a pat down or something of that nature, Your Honor.
I have a question. It sort of goes to the Commonwealth versus Trumbull analogy to the roadblocks, but I want to sort of ask it in a different way. When I read your brief, I'm visualizing these Doberman pinschers scaring these little kids visiting family members. And when I read DOC's brief, I'm seeing these golden retrievers lying on the ground and being as quiet and as careful as can be and scaring nobody. And I think it sort of matters in a way as to whether or not you have to go through the APA here or whether or not this fits into the existing regulatory language of a search, going back to Justice Kaffer's point. that's more like a personal search of somebody, because it's not particularly intrusive. So which vision helps in trying to understand this regulation?
Well, obviously, we are more helped by the Doberman-Pinscher analogy, and DOC is presumably trying to minimize the impact of this procedure by the golden retriever analogy. But I think the essential point here is that it is in nature, whether you envision Doberman Pinschers or golden retrievers, it's different, fundamentally different in nature than a metal detector or a personal search.
I guess that's where I get a little stuck, because I feel a little bit more invaded with a personal search than a dog.
Well, I think that's fair to say, Your Honor, but it's not the level of invasion strictly that makes a dog search different than a personal search. It's a search by it's a procedure by an animal as opposed to a human being. It's excuse me for a moment here. It's just different in many respects. There's the ability to confirm the result. I mean, if a dog, quote, alerts, and you pat down the person, but you don't find any drugs or something of that sort, you have no way of knowing whether that alert was accurate or not, because the dog might alert to a trace or something of that sort.
But it would have served the purpose of preventing contraband from coming into the prison, because there wouldn't have been any found on the person. So there would be some certainty there, and then if it had been found, it would have been prevented from going into the prison. So it seems like it might be effective.
Well, I think that goes back to Judge Kafker's question, is if effective were the end of the issue, this would be a very different case. But the regulation says not only effective, it lists specifics. And when you get to those specifics, the combination of the general language, effective, and the specific language, naming personal searches and metal detectors, limits DOC's ability.
Now, what do you achieve by having the DOC go through the Administrative Procedures Act process? What benefit does that bring about? What would change?
Well, Your Honor, we would hope that the process would be changed in a way to make visitation easier, less burdensome, less challenging to visitors. The legislature, I mean, DOC at the end of the day, if they go through this process, they can do this. They can implement this procedure. But the legislature, in promoting the APA process, has reasoned that by going through and listening to public comment, that where there are conflicting goals here, and there is a conflicting goal, the need for security on one hand and the desire to promote visitation on the other, that where you have these conflicting goals, if you have public hearings, if you do things, that you will end up with a better policy result. And if I can
want to get it, I mean, that certainly addresses whether they should do that and follow the APA, but the issue and have notice and let people chime in about their thoughts about visiting and having to go through a dog search. But how about do they have to? I mean, you've got a statute, the Chapter 124 statute. It's a pretty broad mandate, including safety in prisons. You've got quite a delegation, therefore, to DOC. And as I understand the APA, correct me if I'm wrong, please, I don't think the APA requires that there be this type of proceeding to promulgate regulations.
Well, Your Honor, you're correct that 124 does give, or the statutes in general, and I started out with the two statutes that DOC relies on, that there's no public right. But 124, Section 1Q, says that the commissioner shall make rules and regulations regarding visitation, Your Honor. And I would cite that, and that was the second point I was going to get at, as limiting the discretion of DOC here. Yes, there is a broad mandate to control the introduction of contrabands into the prison, but there's also the legislative command that DOC shall make regulations here, Your Honor. So I think that...
So your argument is, well, they're not, APA doesn't require them to have regulations. They have regulations, and so therefore they have to follow the APA? They have,
in response to your question about, well, the APA doesn't require DOC to have regulations, and I'm pointing to 1Q, which does require them to have regulations about visitation, and you are correct, they did implement a regulation here. They followed the statutory command, and we have our arguments, as stated in the brief, that their existing regulation precludes dog searches, because you can't just look at the effective language, the very broad language that Judge Kafka referred to. You have to look at that language in conjunction with the specific language naming personal searches and metal detectors. And I think, Your Honor, I would point to the Adams v. Dole case, which I cited and quoted in my brief, the gist of which is, if the legislature had intended the general word to be used in its restrictive sense, no mention would have been made of the particular word. So in this case, the general words are search procedure that is effective, but the DOC chose to add on the specific words, may include personal searches and metal detector searches. And those in combination, when you read it together, that the may include restricts the broad application of the general language search procedure that is effective, Your Honor. I think that's...
If I can turn you to a case that you appear to be fond of, which is Electronic Privacy Information versus Homeland Security, Judge Douglas Ginsburg as the author, with regard to the putting yourself through the scanner at the airport. In that case, they did not vacate the present rule. They said because vacating the present rule would severely disrupt an essential security operation, however, and the rule is, as we explained below, otherwise lawful, we shall not vacate the rule, but we do nonetheless expect the agency to act promptly on remand to cure the defect in its promulgation. Would you be prepared to accept that result here? That is, that we do not vacate this particular rule, but we basically say, okay, you still have to do notice and comment.
Well, Your Honor, let me respond this way. The DOC has placed a lot of material in the record about the importance of preventing the introduction of drugs, and I assume that that's what's motivating your question here. And let me respond to that in this way, and I think that I am taking something that one of your predecessors in this court said a long time ago, and that sometimes that what was done speaks louder than what was said. What is being said here is that this is really important, that it's urgent that we keep the drugs out of the prison facilities. When this case was brought, the DOC could have simply held a public hearing and this case would have been over, would have been the end of it. But they decided, for whatever reason, that it was that I assume that it was more important to get an affirmation from the Superior Court and now from this court that they had the power to do this. So they prioritized that over having the public hearing. And I might add that they did amend, since this case is brought, they have amended their visitation regulation in ways that don't impact what we're considering here. They could have very easily added that at the time. We want to do dog searches, added that and gone through the APA process, or they went through the APA process. So I submit to you, Your Honor, that what's been done here speaks louder than what was said, and
Okay,
that under that
but I still have my
circumstances.
question hanging out there.
Yeah.
Would the Judge Ginsburg approach, which is we're not going to vacate the rule, but we're going to require that they do proceed with notice and comment, be a appropriate outcome here to respectful of the importance of of the concern that they have with regard to the smuggling of contraband, as well as respectful of the importance of notice and comment? Would that be an appropriate outcome here?
It's a half a loaf, and I guess we'll take it, Your Honor. Thank you.
Thank you. Mr. Saltzman, good morning.
Good morning. My co-counsel Jennifer Staples is still on the MBTA, unfortunately. She never returned.
We hope she will.
I hope so. Let me start with what is not in dispute in this case, because I think that's all very important. Certainly, narcotics are articles within the meaning of the regulation, which requires that superintendents adopt search procedures that are effective in preventing the smuggling of articles. It's undisputed that drugs, unfortunately, have entered the prisons through visitors. And it's also true that narcotics defy detection by metal detectors. And in small quantities, for example, Suboxone strips tucked under a waistband, defy detection by a patch search, which is a personal search. My brother is correct about that. It's also correct and not disputed that trained canines can alert to the presence of narcotics, and they're used extensively in many other correctional systems, as set forth in the former deputy commissioner's affidavit. And I need not tell the court the devastating impact that the opiate crisis has had in the Commonwealth and also in the prisons. And since this litigation has initiated, it has only gotten worse with the advent of fentanyl, which is 50 times more potent than heroin, and carfentanil, which is 5,000 times more potent, which can harm, sicken, kill people simply by environmental exposure.
Well, maybe that compelling point sort of speaks to what the plaintiffs are looking for. Maybe the end game is not to prevent all dog searches of people coming in, but that, gee, the impact on people visiting a family member in prison is such that if not before, at least as the chief has alluded to, at some point, there should be a notice and opportunity to be heard as to this rulemaking, because maybe there's something DOC can learn about doing this in a way that's less intrusive, less intimidating, and lets people visit family members in an easier way while still achieving all those important points that you just made.
I think there are two parts to the answer. One is the agency looked at the regulation and said, is the canine search already incorporated within the regulation, or do we have to go to public hearing to amend it? We determined that the breadth of the regulation requiring the utilization of search procedures that are effective was broad and admitted to the use of canines. We also determined that this is not a pioneering thing by the Massachusetts Department of Correction. as mentioned, canines are in use in correction systems in many other states, and canines are used in other contexts that are very familiar to people. We see them in Logan Airport, we see them at South Station, we see dogs in all sorts of roles. So I think that the commissioner didn't feel this was something that needed to be done through the public hearing process as a matter of law or as a practical matter. Now, that being said, in an abundance of caution, the commissioner, as set forth in the affidavit, took great pains to educate the public, reached out to the legislature, put out videos on our website, and told people what we were going to do, and went through a process 8 months long before actually implementing the first searches. Now, I'm not saying that that substitutes for a 30-day process if the court deems that necessary, but I'm saying that this is the way the agency was thinking about the problem.
When you say they reached out to the legislature, what did that entail?
Legislators were contacted. It's in the affidavit of former Deputy Commissioner Peter Pepe. Getting down to the legal issue here, I think what we have are two conflicting interpretations of the regulation. The commissioner's interpretation is that the reference to the metal detector, the wand, the personal search are all examples of searches that are effective in preventing the introduction of contraband. They're illustrative, they're not limiting. Plaintiffs, on the other hand, say, no, these should be read under the rules of statutory construction as limiting. We think we're correct for reasons set forth in the brief, but there's something else that I think is very important here.
Can I focus you on that point just for a second? The standard, the standard of whether an existing regulation covers, do we turn to, there's not a lot of guidance. The two SJC cases are the Mass General Hospital case and the Trumbull case, which I can't follow, to be honest. But the Mass General Hospital sets out a standard. It inaugurates a material change in policy. Is that what you think the standard we should be? I'm trying to understand, we have to decide sort of how new this thing is, right? Is this the standard, inaugurates a material change of policy that we would apply to whether the existing reg covers?
I think the first question is to see if the existing reg, as it's written, would cover. Right. You might then ask the second question, is there any other reason that this should go to public hearing? Even
Yeah, I'm just trying to do the analysis. Like
Okay.
the electronic privacy case. So they looked at the airport and they said that going through that imaging thing was an invasion of privacy. That was different.
That's
For example, can I ask, did they, because we all go through the dog searches at the airport, did they, when they imposed that, was that fine?
Well, the interesting thing about the case is that Transportation Security Administration already had in place a policy that allowed it to use the walk-through magnetic detectors. The agency said, our policy says people have to walk through detectors. So it wasn't a question of the regulation. It became a question of the fact that these detectors produce crude images of naked individuals. And here the court said that here's something that implicates some rights well above and beyond everything else. There are certainly privacy rights. That warrants taking this matter to public hearing and hearing what the public have to say about it. Canine searches are nowhere, are not like a machine that sees through clothing. They are not intrusive. They are, well, as suggested, far less intrusive than a pat search. The dog simply walks by the line of individuals, and if it detects the presence of narcotics, it lies down. There is nothing implicating any constitutional right, any privacy right, any search and seizure right that would warrant going out to public hearing where our regulation already provides for the use of any search technology that is effective in preventing the smuggling of contraband.
So I'm trying to figure out where you're going here. So let's assume that let's assume that the next thing you decide to do is to adopt the technology of Homeland Security at the airport and have people go through that screening. Would you have to go through the notice and comment process for that?
If we were to adopt the technology that shows we would certainly have to consider that. But for the canine screens.
Is that a yes? So that means then that
I mean,
so you're not claiming that you can do whatever you want pursuant to this authority. It's not as if you have the authority to do anything. So what are the limitations
We
upon
can
what
certainly
you
use
can't
any,
do?
excuse me, I'm sorry. We can certainly use any search technique that is constitutional, lawful, not contrary to statute.
But that's not the standard, is it? Sorry, I didn't mean to cut you off.
No, go ahead.
No, for going to public hearing, no, that's the, the legal
It's-
standard with respect
Again,
to
that
the
gets
search
back to the
itself.
standard, like, because in the federal case, they didn't talk about constitutional. They talked about having a substantive enough effect to require a notice and comment in the electronic privacy. And then in our case, we talk about a material change of policy. I'm just, it would be nice to know what you think the standard is for what has to go through and what doesn't. How big a change does it have to be?
Well, I think it would have to be far bigger than the use of canines, which, again, are ubiquitous in our society, used in many other contexts. It's not intrusive. Granted, there are some people who don't like dogs. There are some people who have allergies or medical issues, but we've saw fit to provide the opportunity for alternatives. What I need to address is this, where we have the two different.
Can I, before you do that, practically, how are we going to harm you? If we do, for example, the Justice Ginsburg approach, and we kept the regulation in place and require you to go through the notice and comment period, how would that harm the Department of Correction? Because I'm uncomfortable getting in the way of how you screen for drugs and fentanyl there. But I'm trying to understand what damage we will do to you if we do that Judge Ginsburg approach. Keep the regulation in place, but make you go through the notice and comment period. How will we harm you?
Well, I'm not going to argue that going to a public hearing is harmful. It's a legal proceeding. We do it many times with many regulations when we make amendments to regulations. But the starting point here is
How long would that take you?
well, start to finish, approximately 4 months to go through the process with a notice.
So for 4 months, you won't be able to put those dog searches in play and at the Department of Corrections, essentially.
If the court were to hold that we could no longer do the searches until we go to public hearing, and assuming the court did not say, go to public hearing, but you can still use the searches in the meantime, yeah, we would be without the ability to stop narcotics coming in, and more importantly, to deter narcotics from coming in.
But if we were to do the Judge Ginsburg approach, which says we're not going to vacate it, we're just going to tell you to do it and do it promptly, what would be the harm to the DOC? If you said you can continue to do it during the pendency of the notice and comment period, but you must go through notice and comment.
As long as we can use the dogs, it would not harm our ability to employ the technology to detect and deter drug contraband. It's very, very important to keep it out.
I was just going to say, is there an argument, I know you were, the question was from Justice Kafka about the standard, at what point do you have to do the notice and comment? And I thought I heard you say something about the level of intrusiveness matters. Is that your argument?
What I'm saying is that the federal case, electronic information privacy case, looks at things differently under the federal statute, which the courts distinguish between a change that's procedural and one that's substantive. There's a continuum, but in this case, where the regulation already admitted to the use of some kind of detector, the court said that, yes, it's a detector, yes, your regulation covers it, but given the substantial impact on privacy, we think you better go to public hearing.
Or it's a major change. So let's just say
That's
that
right.
the statutory, the delegation from the statute and the regulation allow for you to have dog searches. But this ultimately is going to go to the chief's suggestion about keeping in place the searches going on now, but that we feel like the visual we have, looking at the briefs and the law is, you had the authority, but this is a major change. And if it's a major change, even though you can interpret the general and the specific as just not a limitation, and that the delegation is enough from the statute, this is a major change. And if it's a major change, then it's supposed to go through APA. Is that a standard that we can use?
For a major change, it would certainly have to go through APA, but it is not a major change. It is contemplated by the regulation.
Can it be both? Can it be contemplated by the regulation and be a major change because
Well,
it wasn't in place?
You know, that gets into another problem because if you become too granular there, then any new thing that we do, even if contemplated within the scope of the regulation, would require we go back to public hearing. That could be detrimental to
Well,
the
this is a
commissioner's
big circle.
ability
It
to.
all comes back to how big a deal it is for people to have to go through dog searches before visiting family members.
All I can say is we've now been doing this for a few years without a problem. It's, there was a lot of concern that the sky was going to fall, and it has not done that.
But I guess I understand, and again, I'm not saying that the way it's being done is, but there are different kinds of dog searches. I mean, look at every movie where there is a Nazi trooper and they have a dog with them. I mean, obviously, dogs can be a source of intimidation or not. You may have done it in a manner where you are content that it's not intimidating, but are you saying that nice dog searches don't need it, but rotten dog searches would, or more intrusive, that you can't use a Doberman, but you can use
We use patrol dogs. It's laid out in the affidavit. They're the dogs that are trained to track and to apprehend people by biting and holding. These are completely different dogs who are raised differently, trained differently. We do not use one type of dog to do the job of the other.
My point is not that my point is not that the dog you're using is inappropriate. My point is, are you saying that even a certain kind of dog search may require notice and comment if it were not the benign dog search which you folks have employed?
I'm not aware of any other kind of dog search for this purpose than the dog walking by, sniffing, and then lying down. I can't really address that. I mean, dogs don't perform pat searches or go beyond their level of expertise in conducting searches, Your Honor. Thank you.
All right, thank you.